The law offices of Spar Bernstein with 2 locations in New York, 2901 White Plains Road in the Bronx and 225 Broadway in Manhattan. Call now to make appointments at
1-800-LAWLESS.
Hello, caller. How you doing?
Hello, how you doing?
I'm all right, man. What's your question for Brad?
All right, I'm
You
calling.
gotta put my volume up, please.
Yeah.
I'm calling pertaining to a story that I've seen in one of your newspapers. The Supreme Court clarifying the definition of aggravated felony.
The definition of aggravated felony.
Yes.
The
Court
paper is working.
clarifying the definition of aggravated.
Wait, say that again? You gotta talk up.
The Supreme Court clarifying the definition of
Right.
aggravated felony.
Right.
All right. There was a case there.
In December.
Yes.
Mm-hmm.
Does that case still stand?
Yes, it still stands, but there's no, by the way, just so, the aggravated felony, all right, if someone said define an aggravated felony is about 10 pages of particular crimes that if you are convicted of, makes you an aggravated felon, and if you are convicted of that aggravated felony after April of '96, there's really no relief from deportation. The Supreme Court came down with a decision back in December of 2006, and what that decision was is previously the Immigration Service said that if you were found guilty on a first-time offense of possession of marijuana, not conspiracy, not sale, not attempted sale, but a straight possession of marijuana, and it was a state crime, not a federal crime, but a state crime, and you pled guilty to a felony possession in state court. Prior to that Supreme Court decision, the Immigration Service said, well, if you pled guilty to a felony in state court, it's an aggravated felony for immigration purposes that makes you automatically deportable. Now the Supreme Court, this is what they said in their decision, okay? They defined 2 things. Number 1, they said a first-time possession of marijuana is not, even if it's a state felony, is not an aggravated felony for immigration purposes, no matter what the amounts involved are, unless there is some conspiracy to distribute or attempted sale or sale component to that plea bargain. What they also said is that possession of more than 2 grams of cocaine is an aggravated felony. And that was actually not their holding, it's called dicta, where they discuss, other where they discuss other things, but they happen to have mentioned it, so now that's the law. No, not
Dicta.
There's an A again at the back of it. Oh. Not dicta, not just the first syllable.
Yeah, you may proceed,
right.
Sir.
So, possession of 2 grams of cocaine or more is an aggravated felony. Possession of less than 2 grams of cocaine is not an aggravated felony on a first-time offense. Possession of marijuana, whether it's a felony or not, is not an aggravated felony on a first-time offense. They did not say, though. Mm-hmm. Okay, it's still up for debate.
Right.
Although you have a very good argument to make. Mm-hmm. What happens if the person has 2 possessions? 3 possessions is the third possession, or the second possession, because you're now a repeat offender. Does that make you an aggravated felon?
All right. Okay, sir.
Yes, but in that same article, I understood that they were saying that that if it's not a felony under federal law, and it is a felony under state, it doesn't qualify as an aggravated felony.
That's exactly what I just said. Okay, now, one thing now. Mm-hmm. Okay, just because it's no longer an aggravated felony doesn't mean you're not a deportable person if you plead guilty to this. You are still a deportable person. The only difference is you're not deportable as an aggravated felon. You're deportable just as someone who pled guilty to a drug offense, and therefore you would have all the different reliefs in deportation available to you. So you would still go through the process, but at least you have a fighting chance to beat your deportation case. Wow.
So this wouldn't apply.
Versus if no, fixed, all fixed. All fixed. It's in there. Versus, prior to December of 2006, that made you an automatic aggravated felon, and basically, if you're in deportation and the conviction happened after '96, then it's goodbye, Charlie.
Right.
All
right, sir.
If you had an auto showcase from '94, and was deported like in ordered deported in 96 and affirmed in 97. Does this still affect you?
Well, the person was already deported. That's unfortunately, at that point in time, the law said that possession was an aggravated felony. He is now outside of the United States, and now what you're asking is, can we bring the guy back now that the Supreme Court made this decision 10 years later to say that what he was deported for in 97 is no longer an aggravated felony? The answer is no, simply because his conviction was in 1994, so he had a 212C available to him.
Right.
Even though the Supreme Court, the reality is the Supreme Court, IRA, it gets complicated now, but I'm going to explain it. Okay, the guy was convicted in 94, was ordered deported in 96, the appeals court affirmed in 98.
Okay.
Okay, there's actually two Supreme Court decisions here that are working together. In 1996, when Newt Gingrich was in charge of Congress.
Never liked that guy.
You never liked that guy.
No, never.
Redneck from Georgia.
Never liked him.
And he was in charge of Congress. They passed two very draconian immigration laws, IRA and EDPA. And
Right.
between the two, they expanded the definition of aggravated felonies. They took away 212C waivers. And that's when that 3 and 10 year bar, if you have to go home, you're going to get stuck home for 10 years. All of that happened in 1996.
Right.
Okay. The Supreme Court, now this guy pled guilty in 94, okay, was ordered deported in 96.
Mm-hmm.
So when IRA went into effect April 24th, 1996, anyone who was in deportation after that no longer had a 212C waiver, was considered an aggravated felon, and boom, was ordered deported.
Right.
There was a guy by the name of St. Cyr who took his case all the way to the Supreme Court, and what the Supreme Court said in 2000 or 2001, I don't remember when the St. Cyr decision was, it was either 2000 or early 2001, what the Supreme Court said in St. Cyr is that if you pled guilty prior to April 24th, 1996, which is the effective date of IRA,
Mm-hmm.
then you can still get a 212C waiver. So under that 2001 Supreme Court decision, this guy should have gotten a 212C waiver.
Right.
But the way that the Immigration Service promulgated their regulations is that they're only going to reopen cases for a certain period of time, and only for people who have actually not been deported yet. People who are still sitting in jails and fighting their cases out. People who've been ordered deported, they are not going to reopen their cases. That was the regulations. Okay, so now the guy gets ordered deported.
Right.
Okay, so it's not even an issue of whether he was an aggravated felon or not under this 2006 case, because even if he was an aggravated felon, he was still eligible for the 212C under St. Cyr in 2001.
Right.
Guy gets deported, immigration says, we're not reopening those cases. Okay, now what does a lawyer do? Well, you got to bring a case back to in federal court, or you make a motion to reopen the Board of Immigration Appeals before the judge and get that denied, to the BIA, get that denied, and appeal it into federal court. And most probably, we haven't tried it yet, but most probably what the federal court would say is there's something in law called standing. And what standing is this court have the jurisdiction to hear this case? That's what standing is. Okay, so for example, a silly argument would be a guy from Tibet and a guy from Russia who has a dispute, can't bring a case into a federal court in the United States because they don't have any standing. There's no
right.
jurisdiction.
Right.
Okay, and what the federal court would probably say is, since the guy is no longer in the United States,
Right.
the federal courts no longer have jurisdiction over him.
So in
So
other
probably immigration, and that's basically what the prior laws have said. So if somebody did try that, that's probably what would happen, although my firm has never tried it. I don't know if other people have tried it, but I haven't seen anything successful or not successful one way or the other. But that's probably what would happen.
It's very complicated.
And it is very complicated. And the bottom line is that immigration knows that, and that's why they made their regulations to say we're only going to reopen cases that were people in the United States, people who've been ordered deported. They know you're not going to get standing or jurisdiction over those cases anymore.
true.
So unfortunately, this guy got screwed. That's the bottom line.
Yeah. Sir?
So is there any relief for a person that's been deported?
If they are in the United States,
No, that someone that's been deported to their country, they're sitting in their country all this time.
Then if they've been ordered deported
and
and it
wish
was a
to come
drug
back.
crime, they're not coming back
As of now.
as of
there's
now.
there's no relief at all for them.
No,
None.
no. I mean, as I said, you can make your case into federal court, but I would say you would lose it
Right?
because they would say that you don't have jurisdiction over it.
All right, sir?
Okay, thank you.
All right, no problem.